The death of the Fifth Amendment. In my previous video, hilarious, subpoenaed witness outsmart sneaky prosecutor, we saw how deceitful prosecutors try to trick you into waiving your Fifth Amendment right against self-incrimination. James Walker was essentially arrested and locked in jail for 90 days for no other reason than refusing to assist the government in framing two defendants. No government official was ever prosecuted for Walker's false arrest, false imprisonment, theft of property, obstruction of justice, perjured arrest warrant, or their conspiracy to commit these crimes. Yet another troubling fact is that the Fifth Amendment has been shredded by a series of court interpretations, as illustrated by Mr. Walker's inquisition. The Fifth Amendment clearly and unambiguously states, "No person shall be compelled in a criminal case to be a witness against himself." It does not state that you must assert it. It does not say that you must reveal your grounds for asserting it, or that it does not apply when there is only a possibility that your answer may incriminate you, as argued by Assistant U.S. Attorney Albert Kemp when questioning James Walker. Kemp bases his arguments on seditious Supreme Court rulings. For instance, the Supreme Court claims your right to remain silent is merely a privilege you must assert, when it is a right you need not assert. The Supreme Court also claims you must assert the Fifth Amendment for each question asked, rather than a blanket assertion. And the Supreme Court says you must state the grounds for asserting it, and that you cannot invoke the Fifth on the mere possibility of incrimination. However, the Supreme Court cannot lawfully overrule the Constitution or use strained interpretations to sustain a corrupt justice system, though they do it all the time. Justice Oliver Wendell Holmes was so disgusted he called the Supreme Court jesters, 9 scorpions in a bottle. Indeed, Walker was not given a Miranda warning or an attorney, presumptively because he was not under arrest when he testified during the deposition for the return of his property. But since he was arrested immediately afterwards, and a policeman was in the room who arrested him, we need to examine the relationship of the Fifth Amendment to the famous Miranda case. In 1966, the Supreme Court ruled in Miranda v. Arizona that an arrested suspect must be informed before questioning of 1. His right to remain silent, 2. That anything he says can be used against him, 3. That he has a right to have an attorney present, and 4. That counsel will be appointed if he cannot afford one. This rule was in response to a series of beatings, coercion, and trickery of suspects by the police to extract confessions and incriminating statements. The purpose of the Miranda rule was explained by Chief Justice Earl Warren in that 1966 ruling, quote, "Even without employing brutality, the very fact of custodial interrogation trades on the weaknesses of individuals." He added, "It is obvious that such an interrogation environment is created for no other purpose than to subjugate the individual to the will of the examiner. This atmosphere creates its own badge of intimidation." Close quote. This sounds just like the atmosphere in Walker's interrogation. To repeat, a policeman was present in the room and subsequently arrested him based on his identification testimony. Is there any difference? In 1979, Miranda was reaffirmed by the Supreme Court in North Carolina v. Butler. They ruled that the right to remain silent and the right to have a lawyer present when questioned could be waived, but the waiver must be voluntary, knowing, and intelligently made. It cannot be the product of ignorance, coercion, persuasion, inducement, threat, or trick, and it cannot be presumed from silence. None of these protections were offered in Walker's interrogation. In fact, all the Fifth Amendment abuses that Miranda was designed to prevent, including the presence of a lawyer, were thrown completely out the window. And in other forums that are just as inherently coercive as custodial police interrogations, the Fifth Amendment is likewise trashed. In such forums, even the Fifth Amendment right to remain silent is automatically waived unless you invoke it for each question asked. And in one forum, grand jury inquisitions, the Supreme Court has ruled that the Fifth and Sixth Amendments do not apply. Did the Founding Fathers intend this? The court at a grand jury inquisition must allow you to, 1. Either invoke the Fifth or, 2. Grant you immunity from your compelled testimony. But they don't tell you that, and, just as bad, you are not allowed to have a lawyer at grand jury proceedings to tell you that. What the court doesn't tell you is that you must ask for immunity. Thus, the North Carolina versus Butler ruling means nothing. The courts can and do coerce, persuade, induce, threaten, and trick witnesses into waiving their right to immunity in grand jury proceedings. To illustrate, the Supreme Court heard a case in 1976 wherein the defendant argued that his statements at the grand jury should have been suppressed at trial because he never received complete Miranda warnings of his rights. The court decided against him in United States versus Mondujano, stressing that witnesses have an absolute duty to answer all questions and are legally bound to give testimony. Besides, the court said, the Miranda decision did not perceive judicial inquiries and custodial interrogation as equivalents. The court felt that being denied a lawyer while questioned by a prosecutor and 18 to 23 grand jurors wasn't as inherently coercive as being questioned by a policeman on a street corner. Say what? This abuse was again considered by the Supreme Court in United States versus Washington. The questions presented in this 1977 decision were, 1. Whether a grand jury witness must be warned that he may be indicted by that grand jury, and, 2. Whether he must be warned that his testimony can be used against him at trial if he is indicted. Washington was not warned of either possibility and was not allowed to have an attorney present to advise him. The 7-2 majority decision was that the Fifth Amendment doesn't preclude a witness from testifying, quote, voluntarily, close quote, in matters which may incriminate him. Translated, this means that intimidation, ignorance, and trickery may be used to secure a voluntary waiver of your Fifth Amendment rights after all. Incredibly, Chief Justice Burger made the preposterous statement that, quote, potential defendant warnings add nothing of value to protection of Fifth Amendment rights, close quote. Justices Brennan and Marshall dissented in the ruling, arguing that a waiver had to be voluntary, knowing and intelligently made regardless of the forum. Thus, what the Supreme Court did was recognize the rights of an arrested defendant but ignore those of a potential defendant. As construed by the court, your right to remain silent exists only when you are arrested or put on trial, nowhere else. Although the Fifth Amendment states it applies in a criminal case, that term is not exclusive. It means current, pending, and even possible criminal cases, or it means nothing. The Fifth Amendment doesn't say it's limited to your arrest and trial, and it isn't limited to your case. You can be questioned about someone else's case and be tricked into making incriminating statements. That's what Kemp tried to do with Mr. Walker. The bottom line is that compelled testimony, including physical evidence in any investigation and proceeding, criminal or civil, renders the Fifth Amendment meaningless if it can be used against a person in a current or future criminal case. The courts cannot get around this fact, so what they've done is devise ingeniously worded restrictions and exceptions to render the Fifth Amendment a nullity while pretending otherwise. We've just seen how witness ignorance and intimidation is used to trick witnesses into waiving their Fifth Amendment rights at the grand jury, all with the complicity of dishonest judges. But it gets worse. The Supreme Court has also ruled that you must provide physical evidence against yourself. Thus, the grand jury can compel you to provide any document or record in your possession, either personal or corporate, regardless of whether or not it incriminates you. You can also be forced to submit to photographing, fingerprinting, X-rays, lineups, show-ups, or painful anal probes. In addition, you may be required to provide voice or handwriting exemplars, hair samples, blood and urine samples, or other identifying evidence. This evidence can also be compelled by the police. See Schmerber vs. California, 384 U.S. 757, 1966, Gilbert vs. California, 388 U.S. 263, 1967, and Neal v. Biggers, 409 U.S. 188, 1972. In Schmerber and subsequent cases, the Supreme Court decided that the Fifth Amendment protection is limited to compelled testimonial evidence, meaning verbal testimony. Although the Supreme Court has no authority to amend the Bill of Rights, the Schmerber Court did so anyway. The 5-justice majority in Schmerber said that taking a blood sample over objections, quote, constituted compulsion, close quote, but it didn't force a person to be a witness against himself. The rationale? Because he wasn't compelled to produce, quote, from the mouth, close quote, verbal evidence. Talk about word twisting. Dissenting from the majority's distinction between verbal testimony and physical evidence were Chief Justice Warren and Justices Black, Douglas, and Fortas. Black said, quote, to reach the conclusion that compelling a person to give his blood to help the state convict him is not equivalent to compelling him to be a witness against himself strikes me as quite an extraordinary feat, close quote. Certainly no one wants to see a rapist or murderer set free due to lack of identifying evidence, and it could be argued that in some capital cases it might be necessary and reasonable for such physical evidence to be compelled. But certainly not when the justice system is corrupt. Lab tests of physical evidence are oftentimes administered by dishonest government employees and incompetent technicians. And there's yet another problem. According to the Cato Institute, and other researchers, there are currently over 4,000 crimes and 300,000 bureaucratic regulations that subject you to criminal liability. All activities made into crimes by unelected bureaucrats are unconstitutional because only Congress can make laws. Most are victimless crimes you are not aware of. At least you know to insist on immunity before giving verbal evidence before a grand jury, even though you can't invoke the Fifth Amendment for compelled physical evidence. But, and there's always a but in the law, if you are granted immunity for verbal testimony, guess what, you still don't have immunity. Prior to 1970, witnesses who were compelled to testify were granted transactional immunity. This immunity precluded prosecution for any transaction a person was compelled to testify about, regardless of the nature of the crime, including murder. But in 1970 President Richard Nixon signed into law the Organized Crime Control Act, which replaced transactional immunity with a limited immunity called derivative use immunity, which is also referred to as use or testimonial immunity. This immunity only prohibits the direct use of the testimony itself, or evidence derived from it, from being used against you. In other words, you can still be prosecuted for any crime you are compelled to testify about, as long as the evidence used against you was collected wholly independent of your testimony. However, there are three aspects of this which render derivative use immunity a scam and the Fifth Amendment as dead as the others. One is that while the testimony itself cannot be used directly or indirectly, it can prompt further investigations in a case against you. All a dishonest prosecutor has to say, and most likely will say, is that he intended to investigate these avenues anyway, so it wasn't derivative at all. The second aspect is that this so-called immunity can be further restricted to the, quote, case in chief, close quote. By restricting immunity to the case in chief, meaning the open case, the government is allowed to open another case on you and use your testimony to prosecute you on additional charges. And, thirdly, even where your derivative use immunity isn't limited to the case in chief, all of your testimony can be used against you if you face new charges down the road, even those brought 10, 20, or 30 years later. The scam called derivative use immunity was challenged at the Supreme Court in Castigar v. United States, 406 U.S. 441, 1972. Castigar had been jailed for contempt of court for refusing to testify before a grand jury on the grounds that derivative use immunity, unlike transactional immunity, did not protect him from self-incrimination. Naturally, the Supreme Court upheld this pretended immunity because the court's primary function is to provide a smokescreen of legality for anything the government wants to do. Ironically, for this bit of legal legerdemain, the court had to pretend that pretended immunity isn't pretended immunity. Therefore, the court's artful 5-2 decision was based on the laughable absurdity that government prosecutors don't lie and cheat, thus blatantly ignoring the thousands of cases proving otherwise. What the court said was that the dishonest prosecutors have, quote, an affirmative duty to prove that the evidence it proposes to use is derived from a legitimate source wholly independent of the compelled testimony, close quote. The crooks at the Supreme Court had the gall to label the protection afforded by prosecutors, all of whom are known to be crooks, as substantial and, quote, fully commensurate with that resulting from invoking the Fifth Amendment privilege itself, close quote. Never mind that nothing in the Constitution authorizes immunity, pretended or otherwise, to be substituted for the Fifth Amendment. The only good news, for the time being, is that you still can't be compelled to take the witness stand at your own trial. The bad news is that you may have to in order to counter the false testimony of the prosecutor's bribed witnesses. But the downside of testifying in your defense is that anything you say can be used against you, and probably will be after it is twisted like a pretzel. Another downside is that if you invoke the Fifth to any question at your trial, the jury will perceive you as guilty anyway, since you must be hiding something. Heads you lose, tails you still don't win. The government is very good at substituting things of no value for our constitutional rights. As I proved in great detail in my book, They Left No Crime Uncommitted, How the Government Committed 470 Felonies to Frame Two Men, and Why You May Be Next. It is available on Amazon and at better bookstores. In the meantime, if you want to learn more about the corrupt judicial system, subscribe to my channel and hit the bell notification icon. Until then, stay safe and don't trust anything the government says.